Clerk, we may proceed.
Second reading. Second reading of the Prerogative of Mercy Bill 2025 by the Honorable Alajimbo, Member for Opasalu.
Thank you very much. Honorable Speaker, I rise to
Honorable, wait.
I think you are sleeping or something.
You have to allow, is the speaker who will. Honorable members, order. Member for Jara Central and Nyamina West, order, please. Honorable members, you will recall that the first reading of the Prerogative of Mercy Bill 2025 was done on Friday, 11 July 2025, and today is appointed for the second reading in accordance with Standing Order 66 of 2. Therefore, pursuant to Order 67 of the Standing Orders, I now invite the Honorable Member for Upper Salem to move a motion for the second reading of the bill entitled Prerogative of Mercy Bill 2025. Honorable Member.
Thank you very much, Honorable Speaker. Honorable Speaker, I rise to move that the bill titled Prerogative of Mercy Bill 2025 be read the second time. The power to grant pardon is of ancient origin and is recognized today in almost every nation. The power is usually conferred upon the head of state, and it entails granting pardon to convicts deserving early release from prison or substitute a less severe form of punishment imposed on any person. Section 82 of the Constitution of the Gambia, 1997, provides for the President to grant such pardons after consultation with the Committee on the Exercise of Mercy. But it does not detail how all the committee members are selected, nor does it show how the petition of mercy process is initiated. This bill provides the legal framework for determining how the committee members are selected and how convicts or their family members can make an application for the exercise of the prerogative of mercy. However, the committee remains the same as provided for by the Constitution. The bill further provides for a comprehensive process on how the committee operates from receiving applications to processing of applications and interviews of convicts and victims. The administration of the entire process is handled at the Ministry of Justice. Moreover, the bill stipulates the criteria for qualification of petitioners before their petitions are considered and an opportunity for repetition. It therefore creates clear path from application to recommendation to the President. In summary, the bill creates a legal framework for the prerogative of mercy in line with the Constitution, that is Section 82. And it provides a structure that can be followed to provide the President with very clear guidelines on this. The bill does not in any way create any new positions or does not therefore seek any expenditure on the Consolidated Revenue Fund. I beg to move.
Any seconder, the member for Lower Salem.
Thank you, Honorable Speaker. Honorable Speaker, this is the most important bill so far where a member of parliament brought in the parliament. I know it must come from only Salms. Honorable Speaker, on that note, I also move, I seconded the motion, then I move also a motion, 53, 53C, a motion for adjournment of the debate on this particular bill to be referred to the Committee of Human Rights and Constitutional Matters for other stakeholder engagement. Thank you.
Any seconder? Member for Nyamina West. Then I will put the two questions separately.
Thank you very much, Speaker. I rise to second the motion moved by Lower Salem. Thank you.
Member for Nyamina West, stop what you're doing. Honorable members, remember the second reading, the motion for the second reading was seconded by the member for Lawa Salum the question can only be put at the end of the completion of the process for the second reading before the third reading. And therefore, that question will not be put at this time. And what should happen is for a motion without debate, to refer it to ABC straight. Then I will refer it to ABC either for Committee of the Whole Assembly or to a relevant committee. And yes. Now you will second the motion and stop at that without debate. You may not debate, and then you can move.
I rise to second the motion. Without, no.
No, you will second his motion, but you will not debate. When you second the motion, if you want to debate, you debate. If you don't want to debate, you not debate. So you will second the motion on the prerogative of mercy bill. Then you will tell me that you will not debate, but you want to move a motion.
Honorable Speaker, I rise to second the motion by the member of Upper Salum. And again, second. Now I move a motion to suspend the debate as the standing order to the committee of the whole house or.
Honorable members, order, please.
53C.
Honorable members, there is a motion under 53C to suspend the debate on the prerogative of mercy for the second reading. Any secondary member for Nyamina West?
Thank you very much, Speaker. I rise to second the motion moved by Lowa Salum to move the bill to ABC for committal to any committee that's concerned. Thank you.
It has been moved and seconded that the debate on the prerogative of mercy bill 2025 is suspended and referred straight to the ABC. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable members, it has been moved and seconded that the bill entitled Prerogative of Mercy 2025 be referred to. Honorable members, it has been moved and seconded that the bill entitled Prerogative of Mercy, Bill 2025, be read a second time. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, we may proceed.
Consideration stage.
No. Read the title of the bill. Order, honorable members.
The prerogative of mercy bill 2025 is hereby deemed to be read for a second time.
You just read. You only read the title. Honorable members, in accordance with Order 68(1) of the Standing Orders, the bill is hereby referred to the Assembly Business Committee for committal to either a committee or committee of the whole Assembly. Thank you. Clerk, we may proceed.
Order 67, consideration stage on the Personal Data Protection and Privacy Bill 2024 by the Honorable Minister for Information, Media and Broadcasting Service.
Honorable members, in accordance with Order 72, honorable members will recall that after the second reading stage, the bill automatically should refer to the ABC. Therefore, thereafter, the ABC scheduled the bill for the consideration stage during the previous ordinary session in March, precisely on Tuesday, 25th March 2025. However, the Assembly could not complete the consideration stage of the that's the National Security Council bill. You know, it was varied, the order paper was varied by the Speaker. In accordance with Order 72, honorable members will recall that after the second reading stage, the bill automatically should refer to the ABC. Thereafter, the bill is appointed today for the consideration stage in accordance with Order 72. During the consideration stage, we have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendment to the bill to be debated and voted on. I will now therefore resolve the Assembly in the Committee of the Whole Assembly to give consideration to the bill that is the Personal Data Protection and Privacy Bill 2025. The Assembly now resolves into the Committee of the Whole Assembly. Honorable members, the Assembly will now go into the Committee of the Whole Assembly to consider the Personal Data Protection. Honorable members, order please. The Assembly will now go into the Committee of the Whole Assembly to consider the Personal Data Protection and Privacy Bill 2024 clause by clause. We will be guided by Order 72 of the standing orders during the consideration stage. Clerk?
Clause 1, subtitle.
Where's the? Honorable members, you have your report. Clerk, we may proceed.
Clause 1, subtitle.
Clause 1, subtitle, Chair.
Yes, the committee recommends that the following clause stands part of the bill with the following amendment. The bill to be cited as Data Protection and Privacy Bill 2025. That's the only amendment. What changes is just the year that changes. Instead of 2024, now it's 2025. Yeah.
Now, okay, interpersonal data is data. The bill to be cited as Data Protection and Privacy Bill 2025. It is proposed that clause, yes, Member Panyanija.
It is, if you look at the title there, it is cited here as Personal Data Protection and Privacy Bill. And I'm hearing the chair saying data protection. What about the personal? That's what I'm having here. So title, this bill may be cited as the Personal Data Protection and Privacy Bill.
Order, honorable members, order. Chair.
Only thing changing is the year. Instead of 2024, now it's 2025.
Yes. Use your mic.
I think on the order paper, it is written the, personal data. But on the bill, what you have there is data protection. So
Yes.
we are going by the bill.
No, not necessarily going by the bill, but we have to be led by the committee, their recommendations. If members have
Yes.
otherwise, then we can ask the minister.
No, yeah, that's fine,
Don't
2025.
put off your mic. Don't use your mic. As personal. Huh? You look at the bill, Chair. We'll go to Chair. You know, this bill may be cited as the Personal Data Protection and Privacy Bill. You want to amend that?
No, what I'm saying is the only thing changing is the year. 2024 changes to 2025. Everything else remains the same.
So what? Honorable members, we will, Minister, I take it. Honorable members, you see, when you change the title, if you want to remove personal data, it's going to make a lot of changes. It has to remain. If you remove personal, they're very difficult. You will change the entire meaning. Now, so the committee is recommending only the year. All right. It is yes, Central Birkamano.
I don't think, Chair, we are the ones changing. Can I get the, yes. Personal is missing in the cover. So therefore, if we want personal, we should propose amendment to bring back personal. Yes. No, even the
Order, honorable
inside
members.
also the same.
Order.
Inside the
Yeah, I'll
same.
come to you. Honorable members. Honorable members, what is important, it says the subtitle of the bill. And the subtitle is maybe said as personal data protection and privacy bill. Then we want to change into 2024-25. Go to page, the first page. No, I'll come to you. Have you seen the first page?
Yes.
Subtitle, have you seen it?
Well.
The bill may be cited as the personal data protection and privacy bill. Insert 2024, we said 2025. That's what they want to amend. So now when that happens, if we pass that, the cover will change. It will change. Yes, this will change. Yes. A majority of the member of Cantora.
You see, if you look at the subtitle, where it says this bill may be set as a personal data protection bill and privacy bill, probably you don't need to really go back to change the cover title. What is important is just going in detail now, to it. But doesn't really mean that you must also align the subtitle to the cover page.
It is proposed that clause 1 Okay, on top of page 1, as the minority leader highlighted on the cover, but on top, data protection and privacy bill, it should be personal data protection and privacy bill 2025. It is proposed that clause 1, subtitle, as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. That is it. Clerk, we may proceed.
Clause 2, interpretation.
Yes.
Committee, clause 2, interpretation.
Yes, the committee recommends that clause 2 stands part of the bill with the following amendments. On the data subject means an identified or identifiable living individual to whom personal data relates. Now, instead of saying living, you make it natural, change to natural. And in the personal data also, you say any, to be removed and be read as personal data means information relating to an identified or identifiable individual. So only those two, the rest remains the same.
Honorable members, on 2, interpretation. The bill is not numbered. Are your bill number? Honorable members, honorable members, on close to subtitle, the second page, but the pages are not numbered. Look at the second page. Data subject. The committee is recommending instead of living individual to natural individual. I don't know. Honorable Minister?
Honorable Speaker, can we know why that change from living to natural?
Chair, because the owner of the bill is of the opinion that it should be as it is, and why changing living to natural?
Most of the legislation we have, you don't see living, but it's a natural persons. It's natural. Most of the legislation we have, they call it natural. Naturals, yeah. So maybe, you know.
Yes, Central Baribu.
Amending this to natural because, you know, this is very clear and simple. In lawmaking, it shouldn't be ambiguous. We said living individuals. So what do you mean by natural?
Chair?
Yes, so Chair, it should be natural person or
Yes,
natural
natural
individual?
person, even for the sake of consistency.
Natural person,
Yes, if you check, even controller means the natural or legal person. So it's been very
So,
consistent.
honorable members, the second page on data, and then the next one.
Honorable
Yes,
Speaker,
Chair.
just
Honorable
quickly,
Minister.
is it living individual or natural person? Or natural individual? Which
Natural person. Chair, is that correct? Natural person.
Natural person. Okay.
Now, the next, personal data. Any to be removed and be read as personal data. I don't even know the page. That is the next page.
Do you have a definition for natural person?
Next page, personal data. You'll come back. Can you put up your mic? Next page, personal data. That should be third page, I think. Personal data means any information relating to an identified or identifiable individual. So they want personal data.
Just remove the remove the any. So when you remove the any, now it will read as personal data means information relating to an identified or identifiable individual. The any is removed.
Or is the any that you are removing? Personal data means information instead of any. We are deleting any. Chair. Now, information. What they are telling me, there are many types of information. Because if you say mean any, it can be any other information. Broad. But if you want to delete any, you are restricting it. You are quoting it. So any is more appropriate there than.
No. When we made consultations with various institutions, they came with their legal experts. And that's what they advised, and the committee agreed with them. There is no need to indicate any. It's just when you say it means information relating to any identified information. That's when you say information, it's general. The raw fact. The raw data.
Honorable members, are you following? On personal data, it said means any information, but the committee wants us to remove any.
It doesn't really matter.
Yeah, we'll come to you. Yes, Lower Salum. Usually we allow them to take note, then you, Lower Salum.
I think, Honorable Chair, the any here is justifying the identify or identifiable individual. Means this any is represented here the identify or identifiable individual.
No.
Because now because any would have been better here.
Okay. Honorable Minister, let's now hear from the Honorable Minister.
On this one, either works. Any or information, for us, both of them works.
So are we going by the committee's decision? All right. Next.
Honorable
Chair.
Speaker, if I can take you back to the natural person, there seems to be a slight if.
Okay.
Because if you look at the definition of a natural person, it's an individual human being who has legal rights and duties, such as the ability to be sued and sue, and also to enter into contracts and own property. But people under 18, children, are the natural persons, and this legislation also covers children as well.
Yes, children are natural persons. You know,
No, but can
maybe-
children enter contract? Can they be sued and can they sue?
You know, when you talk about natural person, it's distinguishing between probably living individual or companies or other. That's why you have this natural person, and it includes everybody. But children are defined there. Have you? It's in the
As
bill.
natural persons.
No, children also are defined. You know, you are worried about those under age.
Yes.
But look at page. Look at the first page. The first page, child. They are also defined in the bill.
These are just definitions.
Yes.
No,
So your concern was
my concern is if you put natural persons there and not living, because if you put living beings, anybody who's living, whether child or adult. But legal definition of a natural person is someone who can sue, who can be sued, who can enter into contract. And children are not someone who can own property. But can children enter into contracts? Can they be sued? Can they sue? If yes, then it's fine.
Honorable members, you had the intervention of the Honorable Minister? Yes?
You know, Chair, when you say persons, in general, it doesn't look at whether it is young or old. It doesn't say the age. But you are a natural person, you have the ability to sue, regardless of your age. Yeah.
A member for Birkamana.
Yeah, I'm trying to look at the comparison between the two terms, natural person and that of living individuals. So the information gathered is that natural person, for data protection law, the correct term is natural persons. And it went further to say that natural person is the legal term using international instruments like EU General Data Protection Regulation and other data protection frameworks, and refers to human beings as opposed to legal persons. Whereas living individuals is also technically correct in plain English, but data protection laws only apply to people who are alive, not deceased, but it is less formal and not the standard legal expression.
Help a little bit. If you go to the Constitution, the interpretation section on 230, on the Constitution of the Gambia, if you go, in fact, it's telling you, in this Constitution, unless a contrary intention appears, words importing natural persons shall include, and it lists them. So we are in order.
Good, we move.
Thank you. Now let's continue, Chair, on that's personal data. The next page. Yes, a member for Nyanija.
It's almost 5:30. If you have to sit beyond 6, now is the right time to make a decision.
Yes. Chair, we are sitting beyond 6, right?
Yes, work to finish.
Yes, work to finish.
Work to finish.
Yes, work to finish. Chair, I hear you move a motion.
Honorable members, we will now suspend this and resume the assembly.
Your Excellency, sorry.
Honorable members, the assembly now resume. Honorable members, is fast approaching 17:30. So it's either for any of you to move a motion for us either to sit beyond 6 to complete business, or but that is for you people. Honorable members, if you are not willing to move any motion, then I will again resolve the assembly to committee of the whole house. Then at 6 we adjourn. Move. Yes, Minority Leader. Minority Leader, member of Brikama.
Mr. Speaker, I move that we sit beyond 6 o'clock to complete business.
Any seconder?
I hear my second motion.
Any seconder? Member for
I second the motion strongly.
Honorable member, you remember we are on record. If you want to second, raise your tag.
Yes, I said
Yeah, the member for your councillor.
Yeah, I hear my second motion in stronger style.
Honorable members, it has been moved and seconded that we sit beyond 6 to complete business on the order of paper for today. Those in favor, please say aye. Those not in favor, please say no. The noes have it. The noes have it. Huh? Huh? Honorable members. All right.
Division.
All right. Honorable members, division have been called. Now we will vote. Those in favor for us to sit beyond 6 and complete business, please raise your tag. Those not in favor, raise your tags. Those not in favor, please raise your tags. Those not in favor, please raise your tags. No, my mistake. Those not in favor, honorable members, order. Those not in favor, please raise your tags. Those abstaining, please raise your tags. Those abstaining, raise your tags. Honorable members, the results are as follows. Ayes 9, noes 10, abstention 0. The noes have it. Honorable members, I will now resolve the Assembly into Committee of the Whole Assembly to continue the consideration stage of the district. The Assembly is now resolved into the Committee of the Whole Assembly. Honorable members, the Assembly is now resolved in the Committee of the Whole Assembly to continue consideration stage. We were still on clause 2. Clause 2. It is proposed that clause 2, interpretation as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 3, application.
Clause 3, application, Chair. It is proposed that clause 3, application, stands part of the bill without amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, may proceed.
Clause 4, principles relating to the processing of personal data.
Chair.
Yeah, we have few amendments on this one. The committee recommends clause 4 stands part of the bill with the following amendments. On 4.3b, we recommend that B be removed as it is already covered in A. So on subclause 4.8, the period for which the data can be erased should be mentioned. Again, that one will go back to the minister to give that. And B, the clarity is needed on why data should be erased. The committee has an issue on the erasure of data. So we need to know exactly how long that can be done. And in subclause 4.10, personal date is a spelling error to be changed to data. And be read as a controller must process data in a manner. It's data, not date. So those are the only few amendments we have. But in particular, subclause 4.8, we want the minister to give clarity on the why data should be erased and also the time period.
Honorable Minister, please. Clarity is needed on why data should be erased. And it is.
I'm of the view that data should not be erased. Mr. Chair?
Chair, you are saying if you look at clarity from why it should be erased, but he's saying it should not be erased.
Exactly. But if you look at it, it's saying a controller must ensure that personal data is erased once the purpose for which it was processed has been achieved, or where it is stored for longer periods, subject to subsection 7, shall only be kept in a form that prevents any direct or indirect identification of the subject data. So the issue we had is the committee is of the view that data, we should not erase data.
But then that's fine. We'll go with the committee.
Exactly.
Chair. Honorable, if you look at clause 8, it's in order. Clause 8, Honorable Minister, a controller, the person controlling whether it's investigation or profiling of whatever, for whatever. And then a controller must ensure that personal data is erased once the purpose for which it was processed has been achieved or more, or where it is stored for longer periods subject to subsection 7, shall only be kept in a form that prevents any direct or indirect identification of the data subject. Is correct?
Yes, no. You see, let's use the financial institution, for example, as an example. They collect, you open an account in a bank. They collect your data, you operate the account, and then after a few months, you want to close the account. Now, are you saying that the bank should erase that information that you gave them earlier? Mind you, there's a requirement.
Are they the same? No, you are not referring to that.
No, data control. Let's talk about data controller. Go to the definition of data controller.
Chair.
Honorable Speaker, can I come in?
Minister, please.
What if your account is activated or you close your account? If you close your account, should they still maintain your data or can they erase it?
Yes, in fact, when you look at when you look at banking regulations, when you open an account, the banks, the financial institutions are required to keep your data to a certain number of years. When I was there, it was 7 years. I cannot remember now, but when I was there, you have to keep the data for 7 years, even if you close the account. They're required to keep it for reasons judicial or otherwise. You are required to keep. Now, if for example, you are investigating somebody, and remember, when you are some of these, particularly let's say crimes, for example, and sometimes investigation may take years for you to be able to track you on your telephone number or on your finance or whatever it is. And if the data is erased, that would compromise the investigation actually.
So can I read something I have here?
Now, this is 8, huh? Now let's read 7. Let's read them jointly. 7, a controller may store personal data for longer periods insofar as it will be processed solely in the public interest for achieving or archiving, public interest for archiving, scientific or historical research purposes, subject to applicable laws on the preservation of personal data. But when you read 8, for instance, if it is a subject of police investigation, and they found out of whatever reason you are not culpable or they are done with that, do you still want them to keep the personal data of the individual or to profile the individual?
Exactly. You see, in that situation, of course, it's going to be good interest, public interest to keep the data for a period of time. But not to just erase.
No, that is why public interest, the drafters accommodated that under 7. Read under 7. Read 7. Yes, central variable.
Chair, I think, this language is very clear. And it says it's conditional. It's not saying that directly you go and erase. It says if circumstances arise, do you understand? Where there is no need for the data to be there, it can be erased. So, but in an instance where the data is needed, it will not be erased. So it's very simple.
But,
Honorable Minister?
Yes, I mean, how would you know that you wouldn't need the data later? Because you cannot anticipate that.
No, but that's why.
For example, if you erase the data, then later you come to realize that for the public interest, you need the data. The data is already gone.
That's why that's why it says a controller must ensure that personal data is erased once the purpose for which it was processed, has been achieved, or where it is stored for a longer period, subject to Section 7, shall only be kept in a form that prevents any direct or indirect identification of the data subject.
Honorable members.
Yeah, I think the
honorable members, you see, when you are reading 8, all of us, including Honorable Minister, 8 is telling you if you are reading it, read it alongside 7. It says subject to 7. When your concern arises and that of the minister other issues, then it will not be erased. Based on 7, look at it, read it properly. I think they are correct like this. Can you read? It's correct. Any order? This one is okay. Honorable Minister, are you reading it? Are you reading the two, Honorable Minister? It's telling you, when you read 8, it's telling you, it's referring you to 7. It can only be erased if it is not public personal interest, not needed, no security, that, then you can erase it. That's what it's saying. Now, 4.3b, right, Chair? 4B. How about 4B? Where's the report? Okay, no, it's 43B. Okay, B be removed. Now it is clause 410, huh? 410. Okay, yes, honorable members, where it's, instead of data, they captured dates. Where? Yes, a controller must process personal data. It should be personal data. And wherever it appears. Yes, any order? That's all. That's clause 10. Huh? 4. It is proposed that clause 4 principles relating to the processing of personal data as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk may proceed.
Clause 5, lawful processing of personal data.
Clause 5. Yeah? Clause 5, lawful processing of personal data. It is proposed that clause 5, lawful processing of personal data stands part of the bill without amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 6, processing of special categories of personal data.
Clause 6. Chair.
The committee recommends that subclause 6 stands part of the bill with the following amendment. On subclause 1H, legal claims to be changed to legal services and be read as processing is necessary for the establishment, exercise of defense of legal services or whichever courts are acting in their judicial capacity. So they want it to be changed to legal services.
Why do you want to change legal claims to legal services?
No, a claim is a service that you can render, but the service is general. General service is more general. So the legal service is more general than you say legal claim.
Yes, Chair, please.
But once the defense is there, the service becomes redundant then. Because it says we can only defend a claim. Services cannot be defended. If you want to maintain the services, we need to remove the word defend.
I'm not sure. That's why I ask. I'm not sure why you want to change the claim to service. Legal claim. I don't know. Any, the owner of the bill, what do you prefer?
As long as defense is there, you have to claim it, defend the claim.
So, Chair, do you agree on have you reached a convergence?
So maybe what we could suggest is defend a claim or for other legal services.
Please use your mic, sir.
Yeah, the service is more general. Because you are defending doesn't mean that you're actually claiming for something. You know what I mean? But it could be just like a general, legal service itself, not like you are claiming something in defense. Oh yeah, it's fine. Yes, yeah, we can leave defense. We can remove it. Yeah.
We leave it like that.
Yeah, I think it's fine. We can remove the defense and call it.
It is proposed that clause 6. Yes. It is proposed that clause 6, processing of special categories of personal data stands part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Clause 7, processing personal data of a child.
The committee recommends that subclause 7 stands part of the bill with the following amendment. On subclause 7.3, to be changed to language the child can understand. And it will be read as, where a controller is processing the child's personal data, he or she must ensure that the information about the processing is in a clear and plain language that the child can understand. The word easily should be deleted.
Can understand.
Yeah.
So you want to delete easily. Why do you want to delete easily? where a controller is processing of the child's personal data, he or she must ensure that the information about the processing is in a clear and plain language that the child can easily understand. You know, it's qualifying the language that child can understand. The child can understand 2 or 3 languages, but among those 3, there is one the child will understand better, easily. That's what he said. This is good here. I think this is just qualifying it and to enhance. Yeah, it's just to enhance. Sammy, yes?
I think it should be understood, not easily. You think so?
No, see, you are not dealing with adults. It's talking about children. So that's why the word easily to make it. Yeah, yes, what are you arriving at?
Mika, what I arrive, I already told you.
But anyway, honorable members, are we leaving it like that? All right.
It's okay, let's move.
Honorable members, it is proposed that clause 7, processing personal data of a child, stands part of the bill without amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, we may proceed.
Clause 8, conditions for consent.
Clause 8, conditions for consent. Clause 8, Chair. It is proposed that clause 8, condition for consent, stands part of the bill as proposed without amendment. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, we may proceed.
Part 3, rights of the data subject. Clause 9, right to know and access.
Clause 9, right to know and access. Chair.
The committee recommends that clause 9 stands part of the bill with the following amendments. On subclause 6, go to subclause 1, 2, 3, 4, 6 is written twice. Once to be changed to subclause 7. The numbering. If you look where a controller charges a fee under subsection 5A.
Honorable members, according to him, the numbering of 6. Where 6? Where? All right, yes. So, numbering the last 6 should read 7. It is proposed that clause 9, right to know and access, as amended, stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Members for signing, mentoring, and central body will need to be assisted by officials of the table clerk. Please see them. Clerk, we may proceed.
Clause 10, right to rectification, erasure, and restriction of processing.
Clause 10, right to rectification, erasure, and restriction of processing. Chair? It is proposed that clause 10, right to rectification, erasure, and restriction of processing, stands part of the bill as it is. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, you may proceed.
Clause 11, right to object.
Clause 11, right to object. Clerk? So, Chair?
Committee recommends that clause 11(5)(b) stands part of the bill with the following amendment. Plain language to be changed to the language he or she understands, and be read as the data subject is clearly informed in a language he or she understands of the intention to send marketing communication. So we'll just change that. That's the only change we have there.
Plain language to change to
Honorable
what?
Speaker.
Plain language to be changed to? To be changed to?
Honorable Speaker. Apa bukan juga ini plain B?
Honorable, you are saying the plain language he or she can understand. You are going to delete plain. Honorable Minister for Information.
I think it should be left there because it's trying to say that you should not use any ambiguous language. It should be plain language that is understandable. It does not really spoil anything in the sentence.
Exactly. Chair, I think it is correct as it is. It is proposed that clause 12. Chair, you want to say something again?
Yes.
Please go ahead, sir.
You know, I can speak in very plain English to somebody. To me, it's plain, but it may not be a language the person actually understands.
It may not?
The person can understand. And I'm very plain, simple, plain English, but the person may not understand. So the best is the language the person understands is the best.
Honorable Speaker.
Yes, Chair.
So when you say
Honorable
plain
Minister.
language, it could be any language. When you say plain language, it could be any language, as long as the language is plain.
Qualifying is the language, however plain it might be, the person must understand.
So
no, it could be simple.
But Honorable Speaker, but by
Honorable members, now we are missing the other part also. You know, not only they are proposing to change plain, but he or she understands. Chair, in a plain language, he or she understands. Yes.
That's why we have it in quotation.
Honorable Minister.
if you leave the plain there, it doesn't really destroy anything. What it does is just put emphasis on how plain the language should be. Now, whether you remove it or leave it, for me, it really doesn't matter. But I think we should just leave it there so that for clarification's purpose.
Language the person understand.
Yes.
Okay, that's fine. Let's move.
That's fine.
Ngara.
So, in the plain language, he or she or the persons understand. All right. Yes, Chair.
How do we measure one's understanding of the language?
Committee, yes.
Yeah?
He's asking you a technical question.
Exactly, and that's the reason why the committee recommends that we say plain language. Language the person understand.
No. It's not the same. What he's saying, he's opposed to understand.
Of course, you would have to ask questions. You have to ask questions, like what language can you speak? Do I speak Fula? Do I speak Mandinka? Do I speak English? And then they'll tell you I speak English.
Honorable members, it is proposed that clause 11, right to object as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Chair.
The amendment is, we are leaving plain language. The person understand.
Chair.
Oh, okay. Yes, clerk, let's proceed. Let's proceed.
Clause 12, right not to be subject to automated decision making.
Chair.
Clause 12.
Yes, we don't have any issue on 12, 13, 14, and 15. So we can put it together and we move to save time because we want to finish this.
No, it is proposed that clause 12, right not to be subject to automated decision making, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, let's proceed.
Clause 13, right to obtain assistance from the commission.
Clause 13, Chair. Clause 13, right to obtain assistance from the commission stand. It is proposed that clause 13, right to obtain assistance from the commission stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 14, representation of the data subject.
Clause 14, representation of the data subject. It is proposed that clause 14, representation of the data subject, stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 15, right to remedy.
Clause 15, right to remedy, Chair. Huh? It is proposed that clause 15, right to remedy, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Part 5, offenses. Clause 16, unlawful processing of personal data.
Clause 16, unlawful processing of personal data. Chair.
We have something. The committee recommends that clause 16(1)(a) stands part of the bill with the following amendment. Subclause 1(a) to be read as, in the case of an individual, a fine not less than $500,000, imprisonment for a term not exceeding 3 years or both. That's the recommendation of the committee.
Clause 1(a), that is, on 1, a person who knowingly or recklessly obtains, retains, discloses, or procures the disclosure of personal data without the controller's authorization with the intent of financial gain or to cause harm to specific data subject commits an offense and is liable on conviction to A. In the case of an individual, a fine not exceeding $1 million or imprisonment for a term not exceeding 3 years or both, and what? Or both, and in the case of a body corporate, a fine of not less than 5 million. What are you proposing? A fine not less than $500,000 for A, and imprisonment 3 years.
Honorable Speaker.
Instead of 1 million, you are proposing for half a million.
No,
Yes, Honorable
it's
Minister.
different. It's different. Now, what is proposing here is that in the original draft, it is saying that you cannot fine above $1 million. In the proposed amendment, you cannot fine less than 5, but you can do 2 million, 3 million, but nothing less than 500,000. But you can do, but in the original, you cannot do more than 1 million.
In the original, you can even fine for $1.
Exactly.
Yes.
But in this one, you cannot do less than 500, but you can do 2, 3, 4 up to 5 million, but nothing less than 500.
Yeah.
We go
So-
for the proposed amendment.
Yeah, exactly. So this one gives.
You are proposing.
Yes.
Sorry, what they are proposing.
Yes,
Yes.
that's what we go for.
Okay.
Yeah, because this
You
one
are in
actually.
agreement with the committee.
Because if you do it, leave it at 1 million, in 25 years, 1 million might be nothing. Exactly. Yes.
Now, what I'm being guided is, Honorable Chair, why not instead of, because there are a lot of offenses evolving around that, and a lot of elements involved, why not you, instead of 1 million, you can move the 1 million to 5 million, depending on the offenses and the circumstances, including recklessness. It can be 1 million, it can be 500,000, it can be 300,000, it can be 100,000.
Yeah, we already have on the Criminal Offences Act 2025, the one we passed. Parliament has already given some sort of a guideline where judges can actually follow in terms of fines and number of years. So we just want to, we don't want to tie the hands of the judges itself. So depending on the gravity of the issue or depending on the seriousness of the issue, then they can hit hard or they can hit low. But this information, no matter how small it is, to give it out actually is
No, you know, when they commit crimes based on this one, you are going to prosecute them under the Personal Data Protection Act. You are not going to charge them or prosecute them under the criminal.
No, I'm just saying this. I'm just saying the guideline that was given. So we're just trying to bring consistency.
No, but yes, exactly. You know, that one, for instance, those guidelines, whatever, in the event that those offenses are not specifically mentioned or created, enacted in a law, then you can use those things. But whereas you are specifically enacting those ones, so you just use them.
I was speaking. What he's saying is that with this proposal, you have not tied the hands of the judges, that they can be able to find that is commensurate with the offense, no matter what time. When we make laws, we also think of the future. So here, they cannot do less than 500, but they can do even 5 million. They can even do 10 million.
All right, now that the chair and the owner of the bill, they are all in line. So, honorable members, it is proposed that Clause 16, unlawful processing of personal data, stands part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, you may proceed. What? No. Huh? Well, I didn't vote and I was never the returning officer. No, I was the returning officer, but not the counting officer.
No, but we had questions about the returning officer. There were several questions about the returning officer.
Honorable members. Yes, Chair.
Yes, Chair. Considering the fact that we are almost halfway in the bill, I was just trying to see if it is possible, maybe from now until Thursday, if we can slot it somewhere so that we can complete the bill. Because there are a lot of things that are hinging on this bill that actually I think all of us will be very beneficial. And if it goes beyond this week, we may have a delay. So I'm just begging or urging your indulgence too. And so if we can schedule it maybe Wednesday or so that we can finish, because the rest is not controversial. Yeah, please.
Wednesday, yeah.
Yeah, but
Wednesday is questions, but we took note. Honorable members, the House will now suspend the consideration stage and resume. Honorable members, the House now resumes. Honorable members, we stopped at clause 16, and that's where we're going to draw the court in for today. And any development, the bill will be communicated to you. Honorable members, I want to thank the Honorable Minister and technicians, of course, and thank every member of Parliament who have been with us up to this time now, and now I'll put the question. Honorable members, be resolved that this August Assembly do stand adjourned until Tuesday, 16 September 2025 at 10 a.m. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. This Assembly now stand adjourned until Tuesday, 16 September 2025 at 10 a.m. prompt.